Okay, well, thank you everyone for joining us. Let's start with a word of prayer, if we may, please. Dear Heavenly Father, Lord, we just thank you for your love for us. Thank you for creating us. Thank you for saving us. And Father God, as we seek to serve you and the things we say and do, we pray that the information we have here would be a blessing and that would bring you honor and glory. Bless each one of us, Lord, I pray, and those that we love. In Jesus' name, amen. Okay, folks, I am so glad to be here with you today, and I want to recognize a couple of my partners and compatriots. You'll see Silka Hubbard there. She is at the Kentucky-Tennessee conference and representing that wonderful part of the union. And then Ray Hartwell is joining us from Georgia Cumberland. And so those are your contacts. If you are in Kentucky, Tennessee, or in Georgia Cumberland, you would want to reach out to Silka or Ray at their respective conference offices to drill down deeper, get more information, or follow up on anything that we might say tonight. I am actually in Florida, and some of the things that I say may only pertain to Florida because probate and other issues like that are a state-by-state basis. So 90% of that type of law does transcend to other states, but not necessarily. So, you know, Ray, Silka, if I say something that's contrary to what you guys have, by all means, feel free to chime in. We'd love to hear that as well. But at this point, I'm going to proceed, and you know, we'll take it as we go. So let me share my screen. I know you can see the intro page, and resume sharing. Okay. So this is tips for avoiding the hassles and expenses of probate, and we're going to talk about that a little bit. I am Phil Bond, and I am here in Florida. This is our team in Florida. There's myself and Andrew, Luis, Adeli, and Maria, and any one of us can help you with any of your needs. I want to let you know that all of us, whether we're in Florida or Georgia Cumberland, Kentucky, Tennessee, or Washington State, we all are required to be certified by the NAD, the North American Division. We also are required to enjoy audits every 2 to 3 years, depending on how our rotation comes about. But you can know that our files and our accounting is audited on a very regular basis. And then also we are required to have continuing education each and every year to make sure we're staying abreast with the current topics and current developments that are happening in the estate planning and plan giving business. Membership in the Seventh-day Adventist Church has its privileges. And some of those are, you are entitled to a free consultation with an NAD certified estate planner. That would be any of us that I've mentioned and our teammates. The free preparation of basic estate documents. I've been coached in the past to not use the word free because they're actually not free. We pay for those as part of our ministry on your behalf. So that is for the basic documents. If you need something more complex, you can negotiate that directly with your attorney. But the basic documents, which we'll talk about in a bit, are covered. Free notary services and free consultation with the attorney that will be actually drafting the documents. These tools, these documents are a power of attorney. That document empowers somebody to make legal or business or financial decisions on your behalf if you were to become incapacitated. The healthcare surrogate document, that document allows somebody to make medical decisions only if you cannot speak for yourself. Child guardianships can be very important for our younger members, and we encourage younger members as much as older members to have their estate planning done for that particular reason, child guardianship. Living will, that's a document that says whether or not you would want to be kept alive artificially. Of course, your last will and testament, and a living trust or a trust document, that's not included in the basic plan, but certainly something we talk with people a lot about. All of us do charitable gift annuities, and we all do charitable remainder trusts. We also encourage and support the Southern Union Revolving Fund, otherwise known as SURF. If you are not familiar with that, you should be. That is basically a savings account with the union, and it pays higher interest than what a bank is going to pay. Currently, it's only paying about 1%, but if you've checked bank rates recently, you'll find that that is, easily double, if not triple, what they are paying. And the good thing about it is those deposits are invested back into church and school buildings, the buildings of school and church building projects. So that's a blessing to you and a blessing to the churches and schools. And then cash asset trusts, that's something we can talk about, but know that we have those available. After this presentation, what would your next steps be? And I'm going to slow down a bit. I was afraid I wouldn't have enough time, but I'm making pretty good time. So I'm going to slow down, take a breath. But I think whether you're working with Silka or with Ray or with myself and any of people on our teams, generally the first step is going to be that you would contact our office, contact their offices via email or telephone, and have us send you, we call it an EPP, estate planning package. And it's basically a questionnaire that you would need to fill out in order to get the ball rolling. I don't know if other conferences charge a deposit. We do here in Florida. We started this about 4 years ago. Prior to that, we would have about 10% of the people that we were helping mysteriously disappear. They must have been raptured or something, I don't know. But they would, all of a sudden, we would be helping them, and then they'd stop returning phone calls, stop returning emails. Basically, they had gotten busy with life and lost interest in the process. The problem is we had already paid the attorney. And so we were losing as much as $9,000 a year paying for documents that were never fulfilled or never finished. So we learned that when people have a little skin in the game, they tend to be a little bit more faithful in following through on what they start. So we cheerfully refund this deposit. We don't want the money. We're glad to give it back once the process is completed. But when you send in the initial paperwork, we do request, Florida does request a $100 deposit with that. After that, we send the documents to one of several attorneys that we work with. They review the documents and they will call you. We require them to speak with you directly. And so at that time, that is your opportunity to ask them any questions that you would want to ask them. You have full client attorney privilege, meaning total confidentiality. They won't share with us anything that you ask them not to. And so it's a free opportunity to speak with an attorney about your estate questions or family needs as far as estate matters go. After the attorney has completed the documents to your satisfaction, they will send them to us and we will contact you to make an appointment to sign the documents. We will provide a notary as well as the 2 witnesses that are required here in Florida. Upon that signing, you take the originals and we refund the $100 deposit. if completion has taken place within 1 year of when we started. Okay. Disclaimer. Here in Florida, and I think this is the same in Kentucky, Tennessee, and Georgia, Cumberland, but I won't speak for them. I will say that although we are certified by the NAD, we are not attorneys, we're not certified professional accountants, and we're not licensed financial advisors. So anything we say to you, we highly encourage you to confirm it with the attorney or the other appropriate professional to make sure your question is answered in the most accurate way possible. Some housekeeping things. We ask that you do keep your computer muted. Somebody else comes in the room and starts talking to you, or the dog starts barking, the doorbell rings, that distracts everybody. So if you keep your microphone muted until you're ready to speak, then that will save us from that. Also, those of you that are not familiar with Zoom, you'll notice that if you roll your cursor down towards the bottom of the screen, you'll see several icons pop up, and one of those says chat. If you click on that, a tiny box will pop up, and you can type a question or a comment in the chat box. Now, as the presenter, I'm not able to see that chat box, Adeli, so I'm going to ask you to let me know if there's something there that we need to address. Okay, so we're ready to start our presentation. Adeli, anything that I've left out, or Ray, Silka, any comments you want to make before we go into the nuts and bolts of this? Getting a thumbs up from Ray. Silka, we're good. Okay, good. All right. Adeli, anything in the chat that I need to know about?
No, the only thing is I would like to request everybody if they can go to the chat and write there where they know about the seminar, the webinar. That will help us for future webinars to do the marketing, so we can target the specific way how they hear about our webinar.
Thank you for that reminder. And also a second reminder, we are going to be recording this webinar. So if you don't want to be recorded, you're welcome to, to let it, to sign off or to do whatever you need to do. But hopefully that's not a problem for everybody. But yes, if you would please go down to the chat where I told you about, and just type in, did you hear about it from somebody at church? Was it one of the posters we put up? Was it a mailer or an email that you received? We would appreciate knowing how our marketing dollars are being successful, and so that we can funnel those funds in the most productive way possible. Okay, Adeli, you're seeing my screen okay? And you're muted still.
Let's ask if everybody is able to see. I only see a small one, so I don't know if it is. Do everybody able to see?
Yeah, Silka, you see it. Ray, you see the screen okay? Okay, all right. All right, we're gonna move forward. Okay, so before we get started, I always like to make sure we're all on the same page, okay? So what are we talking about here? First off, we are primarily talking about probate and avoiding the expense and hassles of that. Now, there's a lot more to estate planning, and Silka or Ray or other members of my team who have joined us now, Maria, Luis, certainly Adeli, could explain to you the importance of the estate planning process before you pass away. There are documents, like I mentioned earlier, the power of attorney, or the healthcare surrogate, or the living will. These documents are useful prior to you passing away. Okay, so that's one thing. Then the second category of estate planning that's very important is after you've passed. And that's what most people think about. But I don't want to forget that first category of things, because those are extremely, extremely important. you're still alive then, and you may really need those services. You want to look into that. You want to have that taken care of. So that's fine. But tonight we are focusing on the second half of estate planning, second category, which is after a person has passed away. So now what happens? Okay, well, their final affairs need to be taken care of. Now, that includes things that you might not think about, like their final tax return. You know, IRS needs to be notified that they've passed and the final tax return needs to be done. Who's responsible for that? Well, if you don't have a will, who knows who's responsible? Your will is going to name what we call in Florida a personal representative. Other states may use that term, or other states may use the term executor. They mean the exact same thing. Personal representative equals executor or executrix. So other than taking care of cleaning out the house and doing the final tax return, they need to, the personal representative is going to be the one responsible for distributing your assets. Okay, and so, and the way that that is done is through a process called probate. So probate is the process by which assets are distributed. Some states, Florida is one, that requires an attorney to go through the probate process. I don't believe Georgia does. I'm not sure about Tennessee or Kentucky. A lot of states do not require an attorney, but Florida does. So the attorney will help you through that process of distributing assets. Now, a lot of people say to me, and I've had somebody as recently as last week say, well, I don't want to do a will because I don't want to go through probate. Okay, that's a false statement. That's a short-sighted statement, because understand, if you have assets, then those assets have to be transferred legally to the next person. And probate is the process that takes care of that. Okay, so probate says, all right, so for example, if you pass away, who's responsible for the property taxes on your house? There's no owner because you owned it, but you're gone. So Uncle Sam wants his taxes. Your county wants their taxes. Who's responsible for making sure the grass doesn't get 3 feet high? Your neighbors and your people concerned about your property value want to make sure it doesn't go down. Who's responsible for that? Okay, so that's why somebody's got to be made in charge of that. And that's going to be the personal representative or executor. Now, if you've done a will, then you're going to say who that's going to be. If you haven't, it still has to be done. So the court is going to appoint somebody to take care of those responsibilities. Similarly, who is going to transfer assets and give assets to the appropriate people? If you have a will that names a PR, a personal representative or executor, that person will be responsible for it and will make sure it happens. If you don't have a will, then the court is going to have to appoint somebody to do that. Additionally, the will is going to say how you want your assets divided up. Let's say you have 2 children and one of them is a wildly successful physician or something and doesn't need a lot. And you want to remember them lovingly, but maybe not considerably financially. Maybe you want them to have 10% because your other child, who's also a wonderful child, but maybe they are, in social work or in ministry and are struggling to make ends meet. So you want them to receive 90% of your estate. Well, if you've got a will, you can make that happen. But if you don't, then a judge is just going to say, okay, let's divide everything 50-50. So that's the value of having a will. And that's what the probate process is. The main thing I want you to take away is that if you own stuff, then probate is going to happen whether you have a will or not. So please never make the mistake of saying, I don't want to have a will because I don't want my assets to go through probate. That's not a correct statement. But let's talk about some pros and cons about probate, because what was the title of our survey, of our webinar? How to avoid the hassles and expense. So let's talk about that. First off, there are some pros about the probate process, and there are many situations where I recommend the probate process to folks. Now I'm getting ready to get into how to avoid probate in a minute, and we're going to talk about what's so wrong about probate. But right now I'm just going to say there are some pros to it. Number one, it does provide judicial oversight. Like I said, in Florida, you're going to be required to hire an attorney. You have no choice. Other states that may not be the case, but in Florida, you're required to. You're going to have that expense, but you're going to have that counsel. And then a judge is going to approve every little jot and tittle that is done. So that judicial oversight can be a good thing. Probate can be good when you have a really complicated distribution plan. Sometimes it's good to have that judicial oversight for that reason. And also that judicial oversight can be very helpful when there's contention in the family. When Susie and Johnny don't get along, okay, and some of us unfortunately have that situation, having a judge make a ruling on what's going to happen can have its benefits. The challenge is that there are some challenges with probate. Number one, it's going to take 9 to 12 months, at least in Florida it is. Okay, easily that amount of time. Why? Because number one, you have to get a death certificate. That's going to take a week or 10 days. Number two, you've got to find an attorney. You've got to interview attorneys. You've got to hire an attorney. That's going to take a couple of 3-4 weeks. Then the attorney's got to collect all the information. You've got to determine what the inventory of the estate is. That's all got to be submitted to the court. Somewhere along the line, you've got to run 2 advertisements in a newspaper that gives creditors 90 days to come forward. So you got to wait at least the 90 days. Then the judge has to approve everything. I mean, it is easily 9 to 12 months. Also, I can tell you it is extremely time consuming. I have served as personal representative many times for church members who had nobody else to serve. And I easily spend 100 hours working on that. I mean, it's a lot of work to probate an estate. So, and then also it is a financial burden. The attorney's fees, the court costs, everything that you mail to the beneficiaries has to be done by certified mail. All of this stuff, all of this adds up, and it easily is going to cost between 3 and 5% of the estate value to go through probate. So that's why we want to talk tonight about ways to avoid probate. Now, keep in mind, there are some positives to the probate process, okay? I'm not saying it's all bad. I'm not saying that, there's not times when it's helpful, okay? But in many families, it's an unnecessary burden, okay? So very easy. Number one way that an asset doesn't have to go through probate is you distribute it now while you're still alive. If you know that you want someone to receive a certain amount of money or a certain asset, hey, go ahead and give it to them now. You know, the beauty of that is that you get to see the benefits of that gift now. Let's say you want to give $10,000 to your local church for evangelism. If you give it now, they hold the evangelistic series, 10 people are baptized, and you're there to celebrate that and witness that and love that. Alternatively, you wait till you've passed. You're not there to enjoy. The 10,000 still goes to the church. They still have the evangelistic series. You're just not there to witness and enjoy the beauty of the gift that you gave. So, hey, if it's possible, give gifts while you're still able to do it. Another beautiful benefit of this first strategy is that nobody can contest it because you've done it on your own free will while you're alive. There's no challenging that gift. There's no anybody saying, hey, you know, they did that under duress, or they lacked mental capacity when they drew up that will or whatever. Doesn't matter, because you gave it while you were still around to do so. So number one strategy, give it while you can now. Now the second strategy, add a joint owner. Now, if you are married, and Lou and Connie, you're on my screen here, so I'll pick on you guys a little bit. Lou and Connie Badillo. Lou, if you've made Connie a joint owner of something, and Lou, you pass away, Connie already is a joint owner. Now, I don't know about Georgia and Kentucky and Tennessee. If you live there, you need to confirm this, but in Florida, the default is that ownership is 100% and 100%. So Lou, if you and Connie own something jointly, you don't own it 50-50. You own 100%, she owns 100%. So if one of you passes, it doesn't matter because the other owns that particular asset 100%. Okay, so joint ownership. Now, pros and cons of that. The pro of that is that person, you know, can help you pay bills. They can write checks off of your account. If assets need to be moved around, you've made them a joint owner. They own it just as much as you do. So they can do whatever they want to do with that asset. The con is the exact same thing. The person has full ownership. So they can do whatever they want with that asset. If they spend it, there's nothing you can do about it because you gave them control of that asset. So you would only want to exercise the joint ownership strategy with someone that you trust implicitly, completely. Okay. The second thing that can be a con to the full ownership is if that person is ever sued, there is the potential that that asset, which was originally yours, could get drawn into that lawsuit or that divorce or whatever may happen. Why? Well, because they have full ownership. So I don't recommend the joint ownership strategy. That's strategy number 2. I don't recommend strategy number 2 to just anybody. Okay, Generally, if you are well up in years and are already needing help paying bills or doing things, then you might add a non-spouse joint owner. But it really, again, you have to trust that person implicitly. And so I recommend that strategy very cautiously. But in some situations, it makes a lot of sense and works very well for people. So that is certainly something for you to consider and think about. Another drawback is that if you make somebody a joint owner, okay, Lou, I want you to think about this with me. If you say in your will that you want this asset to go to, let's say, little Johnny, okay, but you've named a joint owner, you've named your brother as a joint owner, okay, who does that asset go to? I mean, your will says one thing, says it goes to little Johnny, but there's a joint owner. Well, in that case, joint ownership takes priority over anything the will would say. So in that case, that asset, that checking account, savings account would not go to where your will said, it would go to the joint owner. And then when the joint owner dies, it goes according to their will. Or if they add a joint owner, it would go there. So it may leave, that asset could leave your family entirely and never make it down to your heirs or offspring. So you want to be very careful, about using the joint ownership strategy. It is the strongest, the best strategy in some situations. Okay. Our third strategy. So our first one was give it away now. Second one is consider adding a joint owner to that particular asset. And I want to tell you, everything is in probate is looked at one asset at a time. So something I want to encourage everybody to do is to make a list of all of your assets. You've got the house, you've got the car, you've got the savings account, you've got the checking account, you've got the IRA or the 401k or the 403b, you've got the insurance policy, you've got the account with Charles Schwab. Okay, we want to look at each one of those assets one by one, because you may employ different strategies for each one of those assets. There may be one asset that you go on and give away now. There may be another asset that you go ahead and add a joint owner to. And then there's the third strategy, and you may use that for a different asset, and that is to name a beneficiary on that asset. Okay, a lot of people don't think about this. I mean, it's obvious to think about it like with an insurance policy. You know, if somebody dies, the first question in everybody's mind is, who is the beneficiary? But in a lot of states, you can name a beneficiary on your checking account and your savings accounts and your money market account. You can walk into Bank of America or Wells Fargo or wherever you bank and say, I want to add a beneficiary on my account. And they can do it for you in about 5 minutes. And once that's done, that asset no longer goes through probate. Why? Because a beneficiary designation takes precedence or priority over anything that your will might say. So giving it away is the first thing. There's nobody can undo that. Then you can have joint ownership. Okay, that strategy applies in some situations. When either of those two strategies don't apply, you can always name a beneficiary. Now, Silka and Ray, I don't know if Kentucky, Tennessee, or Georgia allow for ladybird deeds. A ladybird deed is a deed basically like putting a beneficiary on your real estate. And you can do this on your homestead property, or you can do it on rental property or investment property or your summer home. But a ladybird deed says, when I pass, this property immediately becomes the property of whoever I have named. And that is a wonderful strategy, because a beneficiary, whether it's on your checking account, savings account, or on your home or rental property, they don't have any ownership right now. Okay? If they were sued for some reason, that's not one of their assets, because they only receive the asset as a beneficiary after you've died. So as long as you're alive, they have no ownership, in that asset. So the beneficiary designation is a very important strategy for avoiding probate. You give up no ownership, but yet the moment you pass, that asset. I recently was fortunate to have a situation. My dad passed last year, actually the end of the year before. He had a small savings account over at SunTrust Bank. I was able to walk in. He had made me and my sister beneficiaries. They cut me a check right there for 50% of the amount that was in that savings account. So all I had to do was provide the death certificate and proof of who I was. Just that easy. No probate, no attorneys, no judges, no hassles. Just, I was given a check that same day. So the beneficiary designation was a very effective strategy for that particular asset. Now, when we talk about beneficiaries, I want to ask you again, think about each asset that you own. Which ones of those do you want to have a joint owner on? Which ones of those do you want to name a beneficiary? And then as you're thinking about that, remember to name a backup beneficiary, or what is often called a contingent beneficiary. Why? My wife's name is Sherry. Sherry and I have an account, I have an account. I name her as beneficiary of that account. For some reason, I don't want to make her a joint owner, but I want to make her a beneficiary. Well, if she and I die at the same time, then not only have I as the owner died, but now she as the beneficiary has died. So now what's going to happen? Well, there's no owner, there's no beneficiary. It's going to go to probate. And it's going to go through all of the hassles and expense of the probate process. But if I had named a backup beneficiaries like my children, then if Sherry and I pass at the same time, that's okay. The children are there as backup beneficiaries. And again, on a bank account, they go into the bank. Here's dad's death certificate. He was the owner of the account. Here's mom's death certificate. She was the beneficiary. And here's our ID. Give us the money. And it's just that easy. So, and keep in mind, the most important thing, the joint ownership and the beneficiary designation takes precedence over anything your will says. Many of the people that we work with, not everybody, and that's okay, we work with everybody regardless, but many people want to remember their local church or their conference in their estate plan. If you're employing some of these strategies, don't forget the philanthropy that you want to do. If you're going to name beneficiaries, be sure to name the church as a beneficiary as well. Because remember, if you include your church as a 10% beneficiary or of your will, if they're a beneficiary in your will, but if nothing goes through probate, then the will never sees the light of day. If all of your assets are either jointly owned or have other beneficiaries named on them, then saying, well, I want, and saying in your will that you want the church to receive 10% has no effect, because 10% of nothing is nothing. So remember to keep your philanthropy. Now, there is a fourth way of avoiding probate. And excuse me just a minute. The fourth way is to have a trust. Now, I do entire webinars, hour-long webinars on trust. So I'm only going to touch on this a little bit. I will tell you that 9 out of 10 people that I work with are able to successfully use those first 3 strategies to accomplish what they want, and they don't need to have a trust. But I would bet many of you, just like me, have received a little postcard in the mail that's inviting you to a free dinner, and it's being held by some law office, and they want to talk to you about the benefits of trust. And I encourage you to go and have that free meal. And if they talk you into the trust, then so be it. But I can tell you 9 out of 10 people, at least in Florida, the way our laws are written, don't really need a trust. So let's talk about it anyway, because many of you have heard about trust. Many of you have probably gone to those dinners and heard all the benefits of a trust. There are benefits to a trust, and many times when they are a good way to go. But again, let's put a definition out there so that we all are on the same page. A trust is an entity that you create, okay? It's like you've replicated yourself and created this new entity, and this new entity has one purpose in life, and that is to own stuff. That's all it does. So if Ray Hartwell decides to have a trust, it's going to be in the name probably of the revocable trust of Ray and Mrs. Hartwell, maybe. And so Ray right now owns a house and all this stuff, and it's in his name, or his and his wife's name. He wants to transfer it out of his personal name and into the name of this brand new entity that he's created, called the Revocable Trust of Ray and Mrs. Hartwell. Ray sets himself up as the grantor or trustor of the trust, which means he has full control over the assets. He sets himself up as the beneficiary of any dividends or interest that is earned by the trust. So Ray is the creator. He is the manager of the assets, which we call the trustor. And he is the trustee, and he could be the beneficiary of any earnings that come from those assets. The benefit to this is if Ray passes away, this entity does not pass away, because its life is determined by what Ray has prescribed for it. And so when Ray passes, now he has named himself as the trustee, but he also is going to name a backup trustee, a successor trustee. And so if something happens to Ray, if he becomes incapacitated or he passes, then the successor trustee is already named, and they instantly swing into gear and they execute whatever instructions Ray outlined for whatever assets Ray put into that trust. So it's not impossible. Those assets can be drawn into probate through some legal maneuvering, but generally those assets do not go through the probate process. It avoids probate in most cases. So that's the advantage of a trust. That provides some additional advantages. As I mentioned in the very beginning of this call, probate law is a state-by-state basis. So Lou, if you own property, I'm going to stop picking on you, Lou. I'm going to pick on Nicole there. I see her picture. If Nicole lived in Florida at one time and she had a house here and she was unable to sell it or didn't want to sell it or is renting it out or is letting her adult son or daughter live in it or whatever, she retained property. But then she moved to Georgia and she owns property in Georgia or Tennessee. Now she owns property in 2 different states. If Nicole passes, probate has to be done in each individual state. But if she has titled both of those houses in the name of her trust, then the trust controls those assets, and the fact that she has passed away doesn't matter because her successor trustee will either sell those houses if that's what she has instructed, or again, if she's letting an adult child live in the Florida house, the trust can continue to allow that to happen. So a trust is a way to manage assets, what we call beyond the grave. So that's another benefit of a trust. Number one, it can avoid probate, particularly when you own assets in multiple states. And it allows for those assets to be maintained even after you're gone. So that can be beneficial to some people. The reason I don't recommend trust to everybody is trust can be expensive to establish. In Florida, and again, this varies wildly by state. And Ray and Silka, you may have attorneys that will do trust for much less, but I can tell you in Florida, it's going to be very hard pressed to get a trust done for certainly less than $2,000, maybe even more depending on the complexity of the trust. So and the conference does not pick up that tab. So that would be out of pocket, on your own. So now I was really referring to something called a revocable trust. And that's where, like in Ray's example, he retained control of those assets. There is also an irrevocable trust. And that oftentimes is employed when Ray doesn't want to retain control of those assets because he is applying for Medicaid or VA benefits or other things that limit the amount of assets he's allowed to have in his name in order to qualify for those Medicaid or VA benefits. So again, that's a whole nother webinar, and we may get an opportunity to schedule a webinar like that. We don't have it on, we did one last year. We don't have it on the schedule for this year. Adele, maybe we can talk about, adding that or something. But if anybody wants to talk about it individually, Ray, Silka, Adele, Luis, all of us on the phone, Maria, are fully capable of talking with you about those benefits, and something we certainly would talk with you about if you schedule an estate planning conference with us. So that's, the benefits and the pros and cons of a trust. In conclusion, any assets not jointly titled or have a beneficiary must be probated in order to pass to the heirs, without going, in order for them to go, they would have to be probated if they don't have a joint ownership or beneficiary. A will does not prevent probate, it guides the probate process. Okay, so again, number one takeaway from the seminar, please don't think that not having a will spares your estate from probate. That's not the case at all. You definitely want to have a will. Some people will say to me, Phil, I don't own anything. Do I still need a will? I say yes. Why? Because you don't know what you're going to own on the day you die. You could be killed by a drunk driver, and that drunk driver's insurance company pays your estate $1 million. So now you have assets. Do you want those distributed at the whim of some judge, or do you want to have control over that? So again, everybody over age 18 should have a will. Everyone, yes, okay. It is imperative to create the last will and testament, but it is also a good idea to employ some of these other strategies we've talked about, like joint ownership or beneficiaries, so that those assets at least can avoid probate. And oftentimes you'll have some assets go by joint ownership, some assets have a beneficiary, and some assets don't have either and have to be probated. So that's why I said early on, it's a asset by asset basis. Okay. Taking the correct steps to avoid probate will minimize the stress on your heirs. It will certainly save the probate costs. Like I said, at 3%, that's $3,000 for every $100,000. So a modest estate that has a house and maybe a retirement plan could easily have $500,000 value to it. That's $15,000 that's going to go to attorneys and courts that could have been saved. Okay, minimum of 15, I would say. And also, employing these strategies ensures that your final wishes are fulfilled without contention, without strife, and at as low a cost as possible. If you are interested in receiving more information, you're welcome to contact us. Here is our website, Planned Giving at Florida Conference. Our email, planned.giving@floridaconference.com. Our phone numbers are here with the extensions to Maria and Adele. You can go to this website here, florida.conference. And then under there, you go to ministries and then our department. You can even download the estate planning package right there. You can like us on our Facebook page, our YouTube page. You can even take out your phone right now and scan this QR code, and it'll take you directly to our website. Okay. If you live in Georgia or Southern Tennessee, you'll want to reach out to Ray Hartwell and his team, who are absolutely phenomenal. Would love working with them. And I work with Silka and Ray a lot, and iron sharpens iron, and we help each other. And I can tell you, you'll be get very exciting. That's actually going to be put on by a former FBI agent named Jeff Lanza. I've heard his presentation. It is on cybersecurity and preventing identity theft. I tell you what, I can't encourage you enough This preventing identity theft, if you've ever been through that or even tasted it, it's not pretty. So that's going to be at 6 p.m. on April 26th. Encourage you to join us. We're going to conduct this same webinar that we just now completed in Spanish. And so that's going to be on May 24th. And Luis Reyes, Luis, unmute and say hello if you're still there. Not sure. I know you've got somebody at home that's not doing well. So
He's there. He's there.
Hello, hello.
hello, Luis. We only see the bottom half of you.
Uh-oh.
Yeah,
Okay. That's the better
There you
part
are.
of me.
there you are. That's the best half. All right. Luis will be leading